So as far as, this is the probable cause here, this is not, let me finish. This is not trial, okay? So the people do not have to present anything but what is necessary to show.
People have no further witnesses.
Mr. McCreary, do you have any witnesses?
I would like to call the chief officer that's the investigator on this case, and I also object to him not calling any other witnesses at this juncture because there's a witness list. And I would like all witnesses to be brought here so that I may properly examine and cross-examine these witnesses because they don't have a warrant, judge. Like after we had the hearing when he attested to court, I just had 15 pages. This is all that we have. Where's the warrant, judge? How am I charged? Where are magistrate's signature?
So as far as, this is the probable cause here, this is not, let me finish, this is not trial, okay? So the people do not have to present anything but what is necessary to show probable cause, not beyond a reasonable doubt. So if they want to call one witness, they can. You want to call the officer in charge of the case?
Well,
Can
I call all the policemen that are on the list since he's not calling?
You need to offer of proof.
Pardon?
Offer of proof as to why you need to call them.
Well, because their investigation. This is what I want to question them as to their investigation. How now the law is, I cannot be tried for a crime that I haven't been charged with. There has to be a complaint, warrant, and a request for a warrant. And there's not anything here. How was I even charged, judge? And there's no warrant.
So.
And out of the 15 pages, I looked, and that's a violation of the Fourth Amendment to the U.S. Constitution, judge.
Great. You said you wanted to call the officer in charge?
Yes, it's the officer in charge.
Okay.
And the other officers.
Now, I will allow for the officer in charge because he's here, correct, Mr. Walkie?
Correct.
Okay. For the rest of them, you did not subpoena or bring anyone today.
Well, I didn't know he was not going to put them on here. They're
It's
on
not
the
his
list.
job to call your witnesses.
No, what I'm saying is they're on his list as witnesses. And I would like to basically get the court to
He
have
did
a
not
clear
provide a
understanding.
witness list for an exam.
It's a
In
list here.
discovery and investigation report, I believe, is that what you're referring to?
Yeah, right here, the prosecutor's office witness list. I have a right to this.
Okay,
And I would
so
like to cross.
you have a right to interview them and subpoena them to come to court.
Well,
And
to
you
establish.
ask the people to make them available to interview also before.
Yeah, I understand.
Okay, today we're here.
Going to
And-
6.10, it says I have a right to examine, cross-examine the witnesses of the prosecutor as well as myself.
You do.
And they had an investigation. I would like the court to have a clear understanding so these charges can or cannot be established properly under the due
I
process.
will allow you to call any witnesses that you have subpoenaed that are here today, as well as the people's witness who is officer in charge on this case who is also. Would you like to
Ma'am.
call that? Mr. Martin?
Oh, yes, but may I object to the court's denial of my Sixth Amendment right to call witnesses and also in the MCR 6.110, because to establish a proper investigation, this court to be full aware of what is going on with this case and evidence concerning this case. I mean, these officers have to be brought forward so that we can ask them how they did the investigation.
And I believe that is a matter that you may, if it gets bound over, can address at trial. There was several motions. It's the proper cause here, Mr. McCreary, very minimal.
Well, I mean, the rules are clear and under due process,
They don't seem to be clear because you're still talking.
Well, may I address the court? I mean, you give him the full rights to speak, but I'm always cut off.
Well, it's because you're saying things that really aren't relevant. So the officer in charge is here. Do you want to call that person to stand?
I definitely will.
Step up to the court reporter, give her your name and spelling.
You swear to tell the truth, no truth, and nothing but the truth.
Yes, Your Honor.
And you sit down, just make sure you speak up in the mic. Whenever you're ready, Mr. McCreary.
Can you give me,
like this, sir?
pardon? I hear you. Can you give me your name and badge number for the record, sir?
Officer Edward Wowski, -4753.
You say Pulowski. Okay, so you're the officer in charge,
Yes.
detective? Okay. On the day in question, what time did Norman McCreary come into your station to make the report? If I'm
I don't know the exact time it said, he came right after the incident.
right after this, then, so you didn't take the initiative to write down what time he came in here? He came into your office?
Your Honor, I'm gonna, answer your question whether he knew what time.
I understand.
Right.
Okay, did you, are you the only one that had contact with Mr. McCreary?
No.
Okay, may you tell me who Mr. McCurry started having contact with, in the beginning?
The officer Clennon who was working the desk.
Officer
Clennon.
Clannon?
Clennon.
Oh, Clinton, okay,
Clennon.
Clannon, okay. So you took the report, or Officer Clannon took it?
Officer Clennon took the report.
Okay, and this is the report that's in this file that I made, this report here, sir?
You wanna,
I mean, I'm just asking, is this the report that the
I don't
officer
know,
took?
can you see that report?
That's not a report, so that is a written statement.
Or a written statement?
Yes.
Well, it says an interview, like, it's questions are asked, and then the officer is writing questions, then he's writing the
I'm
answers.
gonna, Jack, because it hasn't been established that this witness has taken that.
Well, he's the chief, officer in charge of this case, so everything falls on him, just like you're supporting Kim Work, sir.
No,
Everything you do falls on her.
For the, what are you trying to establish?
Well, I'm trying to establish time, place, and things of that nature. I mean, there is allegations.
Let's stick to the very specific question you're trying to establish with this statement, what?
Well, I'm trying to establish a time frame. When did he come into the office? When did he speak? Who did he speak with? What time reports were made? You know, to clarify everything in this normal query statement. So I'm trying to lay a foundation as to this investigation.
Okay, and
Your Honor.
that's not the document that the witness has prepared or is familiar with, because if he didn't prepare that, then you can't present that to him to tell him to refresh his memory or recollection about it.
Well, no, I was just asking what time did Norman come in to
Okay.
make a report.
And your response was you weren't sure.
He said he don't know, so.
Yes, I mean, this is one of probably 300 cases I've had since then. I don't remember the time of every case that I had. It's all in the reports, which is public record.
Okay, so do you have the report?
Well, talking about for this report here, yes.
The witness just stated that he's not sure what time, but it's in the report. You have that report that he's referring to.
It says, I can't understand this reading. I mean, can you understand this?
Just
I mean,
but-
5, it says end time.
Don't read to me on.
Oh, it
anything on
says
the-
start time was 5.
Mr.
and this-
McCreary, when I read to me what's in the document, do you have it?
I have a police report, yes.
Okay,
I believe he still has a statement. If it's written pen, it's a statement. The report is all typed.
Well, this was taken on the 10th, Your Honor, the day after the fact that I was.
you have your report or your investigator's report?
It's all in the jacket. There's an investigative report, there's the police reports, there's everything, the warrant.
I don't have a warrant. Where? It's not in here, Judge. He said he gave me 15 pages and he attested this is all he had of last proceeding. There's no warrant here. There's no authorization from the prosecutor here. And then if he pulls anything else out, that's a Brady violation.
And you may have it. What it's showing.
It's not here.
You don't even know what he's about to show you.
what I have that was in the packet, discovery packet, is the Troy Police request for a warrant, investigator's report. It starts on page 3 and appears to go through page 6.
There's the actual report you just had.
And this is even signed by the prosecutor, where they recommend or deny a warrant request. This is not even signed, it's not notarized, these documents are not
Okay, let's
legible.
stick to, do you want to,
Yeah.
present that report to refresh his recollection about the time?
Well, no, I was asking him.
But that was the line of
No,
question.
that was not where I was trying to go. Where I was trying to go, I was asking him to get a basis. He stated that Mr. McCurry, my brother, came into the police department and made a report.
Yeah.
This report showed that he gave a statement on the 10th, so how it happened on the 9th? He said he went in there on the 9th, and this is written on the 10th.
That would be the day after. This is you testifying, first of all. There's been no testimony that
Okay.
anyone came on text.
Okay, well, look, I'm just saying he's objecting to everything, and I have foundation and the right to ask these questions.
Ask about the test.
Okay, so you stated that you're the chief officer in charge of this case, am I correct?
I'm the officer in charge, yes.
So you just stated under oath that you didn't know what time that Mr. McCurry came to the police precinct to make a complaint. Am
Not
I
the
correct?
exact time, no, sir.
Okay. Here, I would like to impeach him. Did you guys seek a warrant from Kim Worthy's office on this day in question or at any time?
I don't remember what date I sent it exactly, I guess we sent the entire packet over to that prosecutor's office.
Okay, at your, what's the word I'm using? At your direction, Did you order your officers to arrest me on the date in question, which when I was brought in for this case?
I didn't tell them exactly what day to arrest you. Once we do any kind of felony case, I gave it to our special operations unit who works out the 10th precinct. I know that there's probable cause to arrest somebody. If they come across somebody, they'll lock them up on that case, yes.
Okay, was there a warrant, sir?
Not at that time, no.
Oh, is there a warrant now?
There should be, because you're recording.
No, sir. Right here, Judge, I would like to amend the evidence where right here, this is the Wayne County prosecutor recommendation. It's blank. It's blank. Now, my paperwork's supposed to be the same as his.
Your Honor, it is blank. The only thing that's different is that it's been redacted with the witness's address between his and ours. And that's perfectly legal, and that's to protect the witnesses unless there's a special.
You talking about the warrant, sir? Not for protection.
I'm explaining why the difference.
I'm not a threat.
So,
That is the last page of the investigator's report. That's not going to be an actual warrant. It's set in with every investigator's report. The
Well,
authorized warrant is going to be the black and white with all the charges on.
okay, can I ask you a warrant where?
So,
there is an information.
Okay, objection, that's not signed, notarized, or approved by court, the court rule.
that would be a motion that you can address if this gets found out regarding the warrant.
Right. Well, I would like to continue my cross-examination if I may, Judge.
Please,
How long have you been an officer? Officer Pulaski, you said it is?
Yes. In Detroit, over 7 years.
Over 7 years. Oh, you've been a police officer in another city?
Correct.
May I ask, where?
City of Westland,
City of Westland. And you say you've been in Detroit, how long now?
7 years.
Are you familiar with the restrictions of the Fourth Amendment to the U.S. Constitution, Article 1, Section 11 of the Michigan Constitution, sir?
I just put for a record that the officer isn't an attorney.
Well, but he's supposed to be a law enforcement officer. How you gonna be a law
Even you
enforcement?
know you don't.
Yeah, I know about the Fourth Amendment, yes.
Okay.
Okay, again, was there a warrant when you arrested me?
I did not arrest you, sir.
Well, your officers, you should know what your officers are doing. Notice the agents, notice the principal. notice the
Question,
principal,
what's the
notice
question?
agent. Okay, did your officers have a warrant when they arrested you?
No.
Judge, I move for dismissal at this juncture because there's nothing authorized by the prosecutor or anyone else. And he just stated he arrested me without a warrant. This is a crime. Now, I would like to state this. In 2001, Department of Justice indicted DPD for dragging that arrest.
Okay,
And this
so
violates the
I'm
Fourth
denying that request. You can be arrested without a warrant.
Can you show me the law where that is?
No, it's not my job to show you that.
Okay, well, I'm saying under federal case law and state case law, under Article 111 of the Michigan Constitution of 1963, as well as U.S. Constitutional Amendment 4, enforced upon the states, they have to have a warrant, Judge.
72 hours.
72 hours.
Charged. At
Well,
some point, I don't know,
hmm,
but that's once again outside of the purview of this exam
well,
today.
they're committing felonies, Judge. This is the
Okay, and I am not the police department, I'm not the FBI,
May I
I'm not
continue?
the
Okay.
Department of Justice. The
Okay.
charges here today are assault with intent to murder, assault with intent to do great bodily harm, less than murder, or by strangulation, weapons, firearms, possession by a felon, weapons, ammunition, possession by a felon, assault with a dangerous weapon, felonious assault, and also 4 counts of weapons and firearms.
Okay. Okay, do you have any video evidence of when Mr. McCreary came into the station, like body cams, which are mandated by law, so far as the desk officer, or you giving an interview, are these articles available?
There is no body cam footage on the front desk. It was all recorded at the station.
Okay, within the station, why haven't you put that evidence into discovery so that the people can have it? Sir.
If that is requested from inside the station, it can be put in there, yes.
Okay, I'm looking for this page. Okay, may I take you to, I believe it's page 6, Detroit Police request for warrant before you was off, please, sir?
I don't take anything, I'm not just taking anything.
You don't have anything, okay. Can I get the court officer to hand this to the gentleman so I may question him about this discovery investigation? I mean,
I don't know, Judge.
What is
Last
it?
page,
Well,
page
no,
of the,
I would like that back, but I would like to ask him a question when it concerns that.
So you want it back, or do you want him?
No, I want him to look at it and I want to question him about it. But once he's done with, I'm going to be questioning him, I would like that paper back, that's all. Okay. Okay, you see the part right there where it says evidence officer. Can you tell me what that says?
None.
None. So how did you move forward if there was no evidence?
Mr. McCray, you established what it is to be looking at.
Oh, okay, that's the, can you read that for the record, sir, at the top of the page?
Well, actually, you would have to ask some questions. That's
Oh,
what we
okay.
know.
Can I see yours, Mr. Prosecutor, temporarily, because he has that?
Yeah, sure.
Okay, you have in your, hand what's called a, Detroit Police request for a warrant, am I correct?
Right.
Okay, on, the top part, it says admissions and confessions, what does it say?
None.
Okay, lineups, what does it say?
Single photo lineup showing Mr. McCreary.
Okay, evidence.
None.
Okay, and then you have the witnesses, then it says video, and you tell me what that says, sir.
Body worn camera footage not available due to the report being taken at the desk.
Okay, and photo.
None.
Okay. So is this typically how the 10th precinct operates? No warrants, no evidence, they prosecute individual citizens? Is this how this happens, sir?
So when I submit one of these,
That's a question, sir. I'm asking the question.
yes, this is typically what ours looks like when we send it in.
No, what I'm saying is this the procedure or the custom that your agency uses when they prosecute citizens so far as no evidence, no warrants. I'm saying, is this a policy or a custom with your department, 10th precinct, sir?
What policy just,
No, I'm saying that the operating of procedures so far as handling of investigations, prosecuting citizens when they're accused of crimes. Is this how you typically handle cases with no evidence, no warrants? You go get people. I mean, is this typically how your department runs?
every case is different, sir.
Okay. Have you done this in your past history in Warren as well as Detroit, Michigan? Do you have a history of this, or
Sending it down warrants, yes, I understand.
without evidence and without arresting people without warrants? This is what I'm saying. Do you have a history of arresting people without warrants or evidence, sir? This is the question.
I'm gonna object because
If so,
Let him finish the objection.
the witness has already testified that he did not arrest him.
Or have a warrant at the time.
well, what I was, Judge, what I'm trying to
You're
establish.
trying to establish way more than
Well,
what's needed for this exam.
well,
This is
what-
a whole, holistic type of approach you're trying to have here with the police department, Worthy, the bench, I understand that, but as far as this case, if you're not getting to specifics about what he did, he's not even seem to be that involved into what
Well,
happened.
what I'm saying is that right now, you had a chief judge that just heard my motion to deny me because they're your supervisor. He's the supervisor of these officers. They move at his direction. If they don't move at his direction, that means they're vigilantes. They're just doing what they want
In
to
your
do.
opinion.
I mean,
So
it's
what is
just-
your next question?
Well, my question is, does he have a history of arresting and charging innocent citizens without warrants and without evidence? And I know I
What's your
have.
answer?
No.
Next
Okay,
question.
I would like, now to establish that he's telling the truth, I would like to file a motion for the discovery under MCR 6.201, which allows this to his background history of complaints for false arrests or things of that nature. And I have transcripts before where this has already been proved in other court proceedings. And I would like to, at this juncture, subpoena his background history as to Warren as well as to Detroit, because if he has done this today to me, he has done this to many other individuals. And I would like the procedural and the substantive due process protection in this proceeding and the equal protection of the law of the 14th Amendment. Judge.
I'm denying that request. I know you like to object. Please object to the record so we can move on.
Judge, I mean, I already placed my objection, I'm being denied my rights to a fair trial.
It's not a
Okay.
trial. That's
I mean, not
that's
my trial. Well, this is a hearing. But I'm still entitled to my rights in the hearing.
Clause here is not guaranteed by the Constitution. It's a statutory right.
Well, if there's a federal right, we have two different opinions, all respect to the court.
And I'm sure mine is right when it comes to whether or not you have a constitutional right to an exam and whether it's statutory.
Okay. All right, I'm ready with my question. Okay, so are you familiar with the law in Michigan so far as state statutes, state laws and things of that nature? Do you have some form of, did you receive some form of legal training when it concerns your job? You went to the academy back in the day, whatever.
Yes.
Okay, did you know under MCL 750.505, misconduct offense that is a 5-year felony that you have committed against me, sir, based on lack of evidence, no warrant, sir?
I'm gonna object.
Well, the objection is not founded, prosecutor.
Let him have, what is, I don't even know what his objection is.
Relevancy, defendant's testifying, he's accusing of crimes,
Argumentative.
argumentative.
I
So the question just doesn't make sense.
Can I respond, please?
Sure.
I mean, it goes for purposes of impeachment, Judge. And then, like I was stating, Kwame Kilpatrick was sent to prison for the same thing that he's doing. And I mean, he was the
Now,
mayor.
You're not about to convince me anything,
Yes, ma'am.
mentioning Kwame Kilpatrick's conviction, so.
All right, well, I mean, can he answer my question? I mean, if he's a law enforcement officer, he should have no problem answering questions.
Well,
of
it's
the law.
not relevant.
Well, it's relevant because he's committed a felony, Judge.
That's an accusation.
It's-
It has not been presented to this court in any matter other than you telling him that he committed.
Well, can I, again, ask this court on the MCR 6.201 Brady versus Maryland, request his background history for purposes of impeachment at People versus Stanaway, which allows.
More discovery?
Yes, I would like to, have more discovery so far as impeaching his witness
So,
because,
Mr. McCreary, if this is found over, I will sign discovery order.
well, I'm just saying is I need it for purposes of the exam under MCR 6.110 to properly, cross
Discovery is
examine.
an ongoing, it's ongoing.
Well,
So today, the exam, if we're in the middle of it, if there's plenty of time to prepare for this day. If it gets found over, I will sign discovery order and you can request.
Well,
Okay?
yes, ma'am. Under People versus State, again, I say that citation I would have today here in court where Judge Robeson dismissed a case against the prosecutor as a sanction for withholding evidence. He knew that his witnesses would be here, then he didn't.
Very, that's an argument that you can discuss during the argument once you're.
So he's not allowed to answer the question that I asked him so far.
No,
So,
I'm just saying.
okay. Are you familiar with Mr. McCreary or your department, the 10th precinct at all? Have you ever had any knowledge of him coming to your department or complaining about your department or anything to that nature?
For this case, I never had any contact.
Okay, are you familiar with the Sergeant Wall that worked at your organization?
Yes.
Okay,
Wait 1 second, sir. Is it the one that's retired or the sergeant?
He's retired.
Okay, because there's two balls there, two sergeants at some point, I just want to make sure I have the right one.
yes.
Okay.
Okay, so you did your investigation. How did you come about knowledge of Mr. McCreary beside with his brother? How did you know how Mr. McCreary looked? What information did you find out where he lived? Did you do a lean check? Did you check the system for pictures or addresses? Did you do any of that, sir?
So typically when I get a case, it pops up, we call it our hopper. It's where it lists all of our cases we got for the day. I make my initial calls, try to make contact with victims, and, get them in for another written statement, because, sometimes, we get a release run. People's minds are elsewhere, or, they don't ask the right questions. I might need more for my investigation. I'd like to get them to come in, either me or someone else who might be you. Get a written statement from them so I get, more of the story. That way, once I do send something like this over, whatever I get, I can put on paper and I send it over to the prosecutor. If they think there's probable cause to go forward, and then a magistrate thinks that, then it gets signed. If they don't, then I can only present what facts I have.
Okay. At your precinct, you guys have a warrant prosecutor?
A warrant prosecutor?
Yes. Typically, I remember from back in the day, even now, like, they have assistant prosecutors available so that they can sign off and stuff like that. And that's relevant. He's part of the thing.
And also, I'm gonna check the notes here.
Mr. McCreary, other than you establishing in your argument that there was no warrant signed, what is your
Well,
purpose?
I'm trying to show how his investigation came forth. I know I've read things concerning the Fourth Amendment. Fruits gathered after an illegal search and seizure are in court. And I'm trying to establish that. I remember from back in the day that they had prosecutors readily available that could sign off on stuff like that. The prosecutor didn't even sign off on it.
Okay, Mr. McCreary.
And I'm just trying to-
I'm sustaining the objection, it's not relevant right now. You can put that in a motion if it gets filed over.
Are you aware that Mr. McCreary, past and present, has come into your precinct, made complaints against your officer there?
Your brother Norman?
No, me, Colonel Michael McCreary, ill.
I'm gonna check the notes.
All not relevant.
It's for purposes of impeachment, Judge. That's how it's
Everything you keep
relevant.
saying is for impeachment.
People versus Stanaway.
Yeah,
Stanaway allows.
It does not say you can impeach on anything. I know that case law does not say that. You can say anything if it's impeachment. That's not how impeachment works.
Well, I'm trying to show and establish retaliation by DP
Okay.
because of numerous complaints against them, because of recording them, putting them on YouTube, where they
Okay.
told
So
an officer
this
to break in the
officer
house.
on the stand doesn't know your brother, attorney, until this case is filed, and doesn't know you. So can we move on to something else about what happened on the date and time of the investigation regarding you and your brother's complaint?
I mean, yeah, I objected again to this court's handling of this case. I had something in mind, but you proved me on this gentleman here. Okay. Did you ever look at Mr. McCrae's picture? It was stated in here that you showed, or one of your officers showed Mr. McCrae, my brother Norman McCrae, a picture. Is that correct?
Correct.
Do you know what picture it is? Do you have a copy of that picture here today in court? Because that wasn't in the discovery.
It's included in my packet. It's an over the APA's office. It's the Michigan SOS picture, provided to me by the law enforcement information that we call lien.
And what came up in the lien? My driver's license, or what came up?
The Michigan SOS picture, yes.
Okay. All right. Your Honor, can I have the court officer show the prosecution's witness something?
Your Honor, it's your witness.
No, I have.
What is it? I don't even know what you're trying to do.
I'm laying the foundation. He's keep trying to shoot
What are
me
you
down.
trying to do?
I mean, I'm trying to figure out how he came in contact with me, how he came about. He just stated in here, so I'm going to show my driver's license. Okay. Did you ever look at Mr. McCrae? I object, right, to the denial of that. Did you ever look at Mr. McCrae's driver's license?
His actual license? No.
Which Mr. McCrae?
Me, I'm talking about me when I addressed me. Well, Colonel McCrae. Did you ever look at Colonel McCrae's driver's license when you did the investigation?
Physical license, the one that's in your wallet? No.
Okay, but what I'm saying is in the system.
It wouldn't be your license, it would be the picture provided by lien.
The picture by lien. Oh, okay. Lien system. I didn't. Okay, so I believe on the paperwork it says a CTN. What is that? A CTN?
CTN?
A CTN, like on judgments, warrants, things of that nature. It says CTN. Then it has ORI.
You asking me what a CTN is?
Yeah.
So that's going to be generated by the system.
No, I'm saying you give me a breakdown and define what CTN.
It's not something I deal with on my end.
Okay, may the people, attorney, since he always wants to object, can you tell me what a CTN means, sir? And help you with it?
I'm not testifying.
Okay, so you don't know the CTN. Did you know that a CTN is?
I don't have objective, bro.
I haven't finished.
I don't see the relevancy of the CTN.
I'm just saying is I haven't finished my line of questioning for him.
Well,
to
I
object.
can't imagine what a CTN has to do.
Well, it's a
with
cargo
assault,
tracking
intent to
note.
murder. I'm sorry, what?
It's a cargo tracking note.
Okay, and that's not relevant today. So next question, I know you objected to that as well. Placed on the record, Mr.
So-
McCrae's objection to my CTN, he's saying that objection. Go ahead.
So you stated that you looked at my ID and whatever else in the link.
Right.
Okay. Did you know that me, Colonel Michael McCurry, reserved his rights not to be governed or controlled by city, county, state, federal officials? Well, I mean, it's relevancy. I tried to establish
It's
relevancy.
relevant to you, Mr. McCrae, but it's not relevant to the case here.
Well, it's relevant because I'm not the strong arm judge. I'm not
Okay.
doing business with the corporation. This is what I've been trying to
And you
establish, but
have-
you're limiting my
I am.
defense. My
I am.
defense, Judge.
I am.
What about the motion so far as additional discovery to impeach him for?
What did I say?
I'm not gonna help him now.
What did I say?
And I have those
What
rights.
did I say?
You said after the fact, it was bound over, you will sign a discovery order, but I'm entitled to that to do a proper
That's
defense.
that's what I said. That's not gonna change.
Well, under federal law, I have a right to present a defense, and this court is denying it. So
I'm not denying you at all. We've been here for over an hour. You've been presenting things to us.
Okay, I can't question this guy because, this officer, because the court and the prosecutor keeps objecting, I'm being denied the right.
Well, maybe because you're not that great at propaganda.
I'm very well, I have a right
You're not
to,
that well versed with the court rules or evidence.
well, I fight with constitutional law, which you have ignored, which you have.
Definitely fight with it.
Well, I'm just saying, under the
But-
Constitution, this court is bound by that.
I know what I'm about. Do you have any other questions?
I mean, I'm being denied, so I would just object. And then I would, once, if it's bound over, I would do a motion for a remand back to this court in front of the circuit court with paid work. And, you know, like I said, I'm in the process, I should be taking that down in this coming week to the federal court. And I would like also to have this case removed to the federal court.
You have
Under
any more
removal statute.
questions of the witness?
I mean, I can't
It's a
question
yes
them.
or no?
No, I can't because I'm
Okay.
being denied.
Okay, any cross?
No, Your Honor.
Okay.
Thank you, Your Honor.
Any other witnesses or defense?
Yes, I would like to call the other witnesses listed on this paper.
And what did I say about that?
And you deny.
I said you did not subpoena them or ask the prosecutor to make them available for you to interview them for the exam today. So they're not here, so you're not prepared to call them.
Well, can I just want to say this for the record, so just in case the higher court looks down the line at this.
Sure.
And like I tried to explain to the court, it was my intention based on the reading of the rule in the case law. It says even where you cannot show actual bias in Michigan Supreme Court, that you would be removed and then I would have time to prepare these motions and documents. And I'm being railroaded by this court as well as the people who just admitted they have no warrants, they had no evidence. I mean,
The
what
higher
is?
court, the higher court, that's why I'm at the district court level, so that's what higher courts are for, so they can address.
What is, okay, but may I respond to say something? Now, the law is clear. I mean, you took an oath under Article 6, Section 2.
Mr. McCreary, I don't want to hear about it unless it's about your argument in response to people resting after they rest. Well, actually, they rested already. And you don't have any other witnesses present.
Well, I mean, I'm denying my witnesses.
You never
And
denied. You were never denied. You had a witness list, you didn't contact, you didn't ask the prosecutors to provide them,
I didn't think
or
this,
make them available for you to interview, or contact them or subpoena them to come to them. This has been adjourned several times. You have plenty of time to do so. I've let you go to the library to research. I've let you even go to the court to file a lien against my house.
I'm waiting.
I've done way more than I should have allowed you to do. So I am not going to adjourn this or provide a discovery request to you or grant that based off of you not being prepared today to call witnesses that were provided to you on the witness. So are there any other witnesses present today that you would like to call?
Well, I would like to respond if I may.
Yes or no?
Because you say I can't because I'm being denied.
Okay, so you don't have any other witnesses?
I mean, I have them. Yes, my brother Charles McCreary. I would like these police officers to be brought into court. Robert Vane, Diana Gerald. I have many other people that are willing to come into court and testify. And I'm being denied that. I would like to just again clarify for the record that I didn't think that you would be moving forward because I was just in a court proceeding with Judge, what's her name? Where she denied the motion, then she sent it to the chief judge. Because from my understanding that if the judge grants it or denies it, then they have to send it to the chief judge. You never ruled granting or denying the motion per the court rule.
You accuse me of being biased, so why would I make a
I
decision?
mean, well, what I'm saying is you
Why would I
could
make a
withdraw.
decision on
What I'm saying
something
so
where you're
far.
saying that I'm biased to you?
Well, I'm about to answer this. Like if you would have said denied, then you had to send it to the chief judge. If you would have granted it, okay, it would have been sent for a blind draw. Per the rules and under people versus,
This is line draw, this is not trial. This is the exam stage,
I understand.
okay? So you don't have any further witnesses.
Well, I do.
Today was the exam,
I mean, I wanted them at the
they're
exam.
just not here because you didn't subpoena them, ask them to come, or ask the prosecutor to make them available. So I mean, in,
Thank you, Your Honor. Your Honor, the people move, bind over the defendant on all charges. It's a matter of, it's a question of fact. We have one witness, that says that the defendant took shots at him, put him in fear for his life. Defendant is a felon, convicted felon. And therefore, he's not allowed to have firearms or ammunition. He attacked his own brother with bricks and a rifle. And there has been no official testimony of him not doing it, other than the defendant during his objections or arguments or whatever they are, saying that I didn't commit a crime. It's a question of fact. It should be found over. And testimony was that it occurred in the city of Detroit, County of Wayne, so this court definitely has the jurisdiction under the court rules and the law to hear this and find this over. And, you know, cocaine man his own brother being shot at him. So we have to find over on all charges.
Mr. McCreary?
First and foremost, I would like to object because by the officer on the mission and the prosecutor knows fully well, there's no evidence, Judge. Not just that, the witness lied here in court today, and he's not credible. He stated that he never forged any signatures or whatever else. And I have evidence to show the opposite, that he committed perjury right here on the stand. Also, the burden is on the prosecutor. I'm innocent until proven guilty per administration of justice. Again, I adamantly object and deny these allegations. He's stating that ammunition, all that, where's the pictures of the guns, Judge? Like I stated before, where's the evidence at? Except my brother, who has lied in the past, and he has a dishonest history, and he has a history of theft. And let me finish. I didn't object to you. I didn't interrupt him. I'm giving my code. I didn't interrupt him.
I'm just gonna object.
Just object to one
That's
thing.
fine. I didn't say that when he was talking.
We've been talking all day.
I'm gonna object because these are pulling facts that you try to get into evidence and they're not in it.
Mr. Walkie, I know this.
Okay.
Objection on the record. Mr. McCreary?
Okay, under Opera versus United States, 348 US 84, the Supreme Court held and accused extrajudicial admissions of essential facts or elements of the crime made subsequent to the crime are of the same character as confessions and cooperation by independent evidence is required. A, the requirement of cooperation applies to exculpatory statements to the same extent that it applies to incriminatory statement. The jury's finding in this case from the admissions of the essential facts together with all other evidence that the guilt of the petitioner had been established beyond a reasonable doubt is supported by substantial evidence.
Beyond a reasonable doubt is at the trial.
Okay, and I'm just reading this, like, to prove that the corroborative evidence need not be sufficiently independent of the statements to establish the corpus delicti. It is sufficient if the cooperation supports the essential facts admitted sufficiently to justify a jury inference of their truth, but those facts plus the other evidence must be sufficient to find guilt beyond a reasonable doubt. Now, I understand that this is just probable cause, but why waste the state's money and continue this vindictive prosecution to proceed, Your Honor? They've admitted that they have no evidence. They've admitted that they have nothing but this man's word of mouth, who is in the community is known as a liar and a perjurer. And I wanted to call Chief Judge Burton, who's in Wayne County 3rd Circuit Court, to establish this, that he lied under oath, that he committed felonies. I mean, the prosecutor's office committed felonies, their witnesses committed felonies. I mean, it's factual. So at this juncture.
You can find all of that at the trial, at the 3rd Circuit.
But again, I would like to object to this court's hearing of this exam for judicial bias, because under Kane versus MPLC, it says that even if I can show bias, justice teaches that the judge should recuse themselves because you have been the target of criticism and so on and so forth.
Only by you.
Okay, but what I'm saying is, and I've been arguing the law, and the court overruled federal law, which state.
Some of it's bad law.
Okay, well, I've researched it, and I've shepherdized it, and it's still good law.
Okay, so, Mr. McCreary, you have made your argument and objected for the record. Would you like to preserve that? Argument that there's no evidence presented today. What the court has to remind defense of is that testimony is evidence, whether you like it or not. I do believe that witness, Mr. Norman McCreary, was credible, and the burden of proof is on them. And they have to show at the probable cause standard, first, assault, intent to murder, that the defendant tried to physically injure a person, another person. There's testimony that the defendant, Mr. McCreary, tried to by not only aiming but also firing a gun at the complaining witness. Second, that when the defendant committed that assault, he had the ability to cause injury. In this case, he didn't have the ability. That was a deadly weapon that would definitely cause injury. And third, that the defendant intended to kill the person he assaulted and the circumstances did not legally excuse or produce the crime. That would be a question of fact for the trier of fact as to the intent of what Mr. McCurry was doing. Pointing the gun, and I do believe in the probable cause standard, pointing the gun and shooting someone shows intent to kill. As far as the remaining charges, assault with intent to commit by the harm less than murder is lesser included, satisfied by the evidence of testimony. The count 3, firearms possession by the felon has been established in exhibit 1, in which Mr. McCurry was not eligible to be in possession of a firearm, as well as count 4, ammunition in the weapon satisfies count 4, ammunition possession by a felon, and count 5, assault with dangerous weapon, felonious assault, has been satisfied based on the same testimony from complaining witness and of course the 4 accompanying weapons, felony firearm charges. So Mr. McCurry, you're going to be bound over to 3rd Circuit Court, Framework Hall of Justice for your arraignment on information date of June 29th at 9:00 a.m. I do not know if it'll be on Zoom or if it'll be in person. It depends on which judge you draw. Anything else from either party?
No, nothing from the people, Your Honor.
Mr. McCurry, other than your objections?
I would like to, place my objections on the record because throughout this entire proceeding, I feel that this court has been biased, when it comes to rulings. They've even allowed this, prosecutor to, use state law to supersede federal law, as stated in, Cohen's versus Virginia, that is considered treason against the United States Constitution. These are landmark cases. And also, the witness lied under oath by stating he didn't do this, and that. And I mean, under substantive due process, the U.S. Supreme Court held that no matter what rules you create, you must use fundamental fairness.
Mr. McCurry, you've already written that.
Well, I mean, you asked me to have anything else to say.
Anything else? Anything additional?
Well, I'll just let you buy me over. And
Okay.
can I say one more thing? Again, like I challenged jurisdiction before testimony was even brought
And
in.
I deny it.
And, okay, but the law
Do you want the
mandated.
discovery order signed? You brought mine over?
Yeah.
Okay, and what was it specifically that you?
I mean,
wanted?
I would like all the officers' background history, Kim Worthy's. I would like the individuals here today because it shows a pattern of history of felonies being committed against citizens.
So what I'll do is I'll sign this discovery order here, and if you want to expand it, with the new judge that you get across the 3rd Circuit, you can ask for those additional things like Kim Worthy's background. I'm not giving that. Short order, I don't even know what that,
Well, what I'm saying is so far she's the chief officer of the county.
yes.
And everything,
And I am not going to do that.
and everything that her subordinates
I'm
do,
signing a normal
well, what about the
court
bond?
scale certified discovery order for you to make sure that you have everything in any video. It was mentioned that there was video possibly at the police station. This will get you that into the goods, okay?
Okay, well, what about the bond? I mean, I didn't run, I'm not a runner. Why do you got this tether on me? I mean, I can't get out and work like I need to. I can't get out and move. I mean, I don't know what my brother said. I'm not trying to do that. This is a complete fabrication.
I give you a lot of leeway.
Pardon?
I give you a lot of leeway.
I
I'm going to
mean,
continue
I
by.
have a right to live. And my liberty is being restrained by these people who are committing felonies.
And the other option is within the Wayne County Jail with assault and attempted murder charges. 629 at 9 o'clock, okay?
Okay, guys, that was the hearing. What a wild one, huh? So it's crazy how he kept bringing up, Kim Worthy, the head prosecutor's office. Like, he went off about her and, and he wanted, I guess, things that she was doing and guilty of that could be found on file that he wanted to prove and show paperwork for. but the judge wouldn't allow it because it just wasn't relevant to the case. And he kind of pushed it to the point where he wanted her to be subpoenaed, to be put on the stand, but again, this wasn't a trial, so she didn't allow it. But he was able to question the officer, and you could tell he was all over the place. He didn't know how to word his questions right, which, you know, he could have benefited for having an attorney, especially in this case, because with his questions, he was all over the place. He didn't know how to word things and lay down the foundation correctly, and the judge just shot him down because this wasn't a trial. You know, not here at this type of hearing. But probable cause was found, and she sent the case over to Third Circuit Court in Michigan in front of Judge Blunt. I will show you all the paperwork from it. You guys will not believe the outcome of this case. The jury found him not guilty, and you will see that in the paperwork that I'm gonna show. So with him being found not guilty, it makes me believe like some of the questions that, or some of the things that he was saying about his brother and how his brother lied like under oath, that's perjury, and about the officer and the way that his brother was like driving around without a license. His brother's a sovereign citizen as well, and the way that he was handling like his mother's offenses and house and everything like that. He signed his brother's name so that they could come and testify and be put on the stand. You know, and he constantly brought this up throughout the hearing, and, you know, again, it wasn't the trial, so the judge just wasn't, you know, really having it and wouldn't allow a lot. And I don't know if it was like the officers, but he claimed, you know, there was no gun, there were no bullets. The whole story was fabricated. So I don't know how he, you know, it just makes me wonder, like, he was found not guilty. So I feel like a lot of what he was trying to say and trying to bring up was true. And like, again, he could have benefited having an attorney on this case and helping him out, because this wasn't a trial. So, you know, he was just heated, and I don't blame him. Like, if I was charged with all these charges and it was all fabricated and all of this, and my brother was lying and all this, like, it, you know, I would have tried to, if I was like, say, him, I could see why he was trying to bring all of this in this type of hearing, but he just didn't understand that this hearing wasn't a trial. So it makes me wonder, like, I don't know anything about like the trial and what happened, but I mean, he got off and he was found not guilty, so that just makes me believe everything he was saying. He just didn't know how to, and it wasn't the right hearing to do it. But, you know, a sovereign citizen win. I don't think, now when I say sovereign citizen win, like, it's not because of what they believe in, their laws or their theories and all that. That's not what I'm saying for as a sovereign citizen win. This is just like people lied, and he was able to prove that at trial finally, and good for him. Good for him. Like, you know, I don't know what I would do if I was charged and everything was a lie. Like, that would be frustrating and hard to deal with. Thank you guys for watching. Have a great night.